Recording in progress.
Good morning, everybody, and welcome. Thank you so much for joining us today for our webinar, Navigating U.S. Tariffs and Trade Rules. I'm Celeste with the Equipment Marketing Distribution Association, and we are very pleased to have Steve Sampson from Phil Patterson joining us today to share his expertise and provide a mid-year update on U.S. tariffs and trade rules. But before we get started, just a quick housekeeping note. Feel free to submit any of your questions throughout the presentation in the chat, and we'll do our best to address as many of these during the question and answer period at the end. So, Steve, thank you so much for taking the time to be with us today and share your expertise with all of our members. And so with that, I'm going to turn it on over to you.
Got it. Thanks, Celeste. All right, everybody. Yeah, as Celeste said, we're going to talk about kind of a mid-year update of the tariff and trade rules that have been changing all over the place. We're actually probably going to focus mostly on kind of second quarter up to the beginning of August here. Some of the first quarter stuff is kind of old news at this point. So, but there's plenty that happened in the second quarter and the first part of August here to keep us plenty busy. So. We'll go ahead and jump right in. We'll kind of look at three different categories here. We'll look at what happened with tariffs. We'll talk a bit about USMCA, and then we'll also talk about kind of customs enforcement and what's going on there and what's been changing there recently. So we'll start with just kind of quick update here on IEPA refunds. If you guys remember back in late April, phase one of the IEPA refunds came out. That was for any of the unliquidated entries or liquidated entries up to 80 days past their actual liquidation date. And hopefully you guys, if you have, I'm sure some of you probably have some IEPA refunds coming to you or already did. So hopefully you guys already have kind of filed for these. There's been a huge success with that. We've seen, I think about 120 billion in refunds has been issued. We've had some customers that've got substantial refunds here, but so if you've already filed, great. If you haven't filed, I would still go ahead and file if you have any entries that are eligible. This is going to kind of be your least contested way to get those refunds back. But I would hurry up and do it because a lot of the stuff that was sort of at the beginning of the IEPA tariff phase is starting to, or has already kind of liquidated out, and you're sort of coming up to the deadlines of getting past that day. Not that you're out of money or out of the ability to get money there, but it could potentially be more difficult. Cape Phase 2 came out at the end of June here. Probably no one in this audience has anything that's under that. That's for reconciliation entries. And reconciliation entries are kind of a specialty thing. They're for entries that kind of change a lot. So probably not something that anyone here needs to worry about. But if you are filing reconciliation entries, those are eligible for refund now, as long as they haven't been had the reconciliation entry filed, the actual reconciliation piece of it, which usually comes a year after the initial entry. And then you got Cape Phase 3. I say here it's projected in late July. There was never actually a date given for this, so you can see, but the projected date of late July, we're already well past that. That was always kind of a rumored date. So, that doesn't mean that Cape Phase 3 doesn't get announced tomorrow and they'll start pushing forward with it. In fact, it's already rumored that Customs has the capabilities built and they're working towards that. But one of the major hurdles for that is it's currently under appeal by the Trump administration. The Trump administration feels that anything that's actually fully liquidated should not be eligible for refund, or at least should not be eligible for refund without having some sort of lawsuit in the Court of International Trade, the CIT. That kind of flies directly in the face of the initial whole Cape refund ruling from the CIT. When the judge actually issued the refund ruling, he kind of did it across the board because he said, "I don't want to tie up the Court of International Trade with hundreds of thousands of the same litigation of people suing through the court just to get a refund for something that's already been done. I just want to let's just refund everything and move on with this so that we can get past this and not use the resources of the court for that." The Trump administration is actually trying to force the exact opposite here. So this part of the phase is seems like it's going to be more contested. That doesn't mean that you're completely out. Um, you do have 2 years after liquidation to file suit with the CIT. So if it does come down to having to file a suit, you're able to do that and still probably recoup your money. It's just a matter of having to pay an attorney to file the suit, and is it really worth it, and how much is going to was going to happen. So there is a court case on this next week, I believe. So something to watch if you have liquidated entries or you're worried about this. Keep an eye on that. There should be news forthcoming on that, and kind of see where we stand as far as this refund process is and how it develops. So something to keep an eye on there. Um, Moving into 232 tariffs. So 232 tariffs are the kind of what commonly referred to as steel, aluminum, copper, the metal tariffs. Um, Really, this has actually expanded quite a bit. This has moved into upholstered furniture, silicone chips. There's several other things, auto parts. There's a whole bunch of stuff under this. Aircraft parts. So for the most part, we're going to focus on the metal piece here, on the metal components here. But if you're dealing with any of those other commodities in any other aspects of your business, you may want to go dig a little deeper into the Section 232 tariffs because there's a lot of moving parts here and a lot of changes that have happened over the last couple of months. But for our sake, we'll just kind of look at the aluminum, steel, copper part of it. Late April, the 232 tariff dropped the metal valuation component. Before that, right, you had to go out and find how much steel was in it or how much aluminum was in it, what was that aluminum worth, and then you paid the 232 tariff on the value of the metal, and then you had to do another calculation for the value of everything else, right? That was pretty problematic, and customs kind of recognized that, and they sort of retooled that tariff, and now there's sort of this four bucket system. You have a 50%, a 25%, a 15% through 2027, and an exclusion category, an exclusion bucket. The 50% is basically the base metal stuff. It's just, chunks of steel, chunks of aluminum, raw rolled aluminum, that kind of stuff. That's where that kind of sits. Anything the Chapter 73 kind of stuff sits there. The 25% is the derivative stuff. So anything that's really made out of steel or aluminum or any of that. If you're in that category, then that's where you probably end up. The 15% started as mostly construction machinery. That was sort of a nod to the fact that we need construction machinery. If the whole point of all these tariffs is to build up our infrastructure internally, we need to bring in construction equipment and be able to give some sort of tariff relief to the guys that are bringing that stuff in. And then that exclusion category is just kind of some of the stuff. Some of the stuff fell out of the derivative list. They got rid of it altogether. Then there was a couple of specific exclusions for the UK, I believe, and then there was an exclusion for if the item you're bringing in is less than 15% metal content by weight, you're also able to exclude yourself from the 232 tariff. When that initially came out, there was some agricultural machinery that was placed on that exclusion list. So if you were paying that before, maybe you're not paying it now, which is a good thing. But there still was a fair amount of that. But then in June, they came out with a second list and moved a lot of agricultural machinery categories into that 15% bucket. So really a lot of the agricultural stuff that most of the members here are importing is probably moved into that 15% bucket, and that's good through the end of 2027. And all four of those buckets now, right, you're paying on the full value of the product. You're not paying on any calculation of of how much the base metal was worth, or how much the valuation of any of that, right? It's just whatever the value is on the commercial invoice, that's what you're going to pay the 25 or the 15% against. The only exception to that is that 15% rule, right? If it's less than 15% by weight of the product, then you don't have to pay the 232 tariff. Um, there are intentions to expand this. There's they're currently requesting public comment for the expansion of several components of this. And you can see the list is kind of random. Brass woodwind instruments, parts of welding machinery, fire extinguishers. There's a bunch of other stuff on here that's just kind of random stuff. Stuff that is specifically kind of interest to this group is potentially linear hydraulic motors, and also trailers, including self-loading and unloading trailers for agricultural purposes. Semi-trailers also fall on this list. That could potentially be uh, subject to 232 tariffs here in the near future. And the reason that that's particularly important is 232 tariffs are they're not like the IEEPA or the 122 where there's kind of question of legality. These have been around. These were actually the first set of tariffs that went in under the previous Trump administration back in 2017, 2018. And so these have been pretty battle tested. They're once they're in place, they're pretty set. So as these get expanded, and it's one of the tools that the Trump administration wants to use to get these expanded. Once they're kind of on there, they're kind of hard to go away. So you kind of want to keep an eye on that, especially if you're doing anything with those ag trailers or hydraulic motors. The ag trailers would probably go in at the 15% level, at least initially through 2027. The linear hydraulic motors would probably go in at the 25% level. So next tariff we're talking about is Section 122 tariffs. Section 122 tariffs were the universal 10% tariff that happened right after the IEEPA tariffs were ruled illegal. So this was the 10% tariff kind of across the board on everything. It went into effect really shortly right after the IEEPA tariffs were ruled illegal and they couldn't collect them anymore. This tariff was always meant to be a stopgap action. Legally, this tariff can only apply for 5 months of time. After 5 months, it either requires an act of Congress to extend it or it expires. And you see, in this case, it expired. There was no act of Congress to extend it. So as of 7/24, you're not paying this tariff anymore. Um, Technically, this tariff was also ruled illegal. I don't know. There is litigation against it. My personal opinion is, and this is only my personal opinion, that I don't think it's going to go much further. I don't think we'll see refunds of this like we did with the IEEPA tariffs, just because these were much more kind of baseline, and because of the short time frame that they actually were there. My personal opinion is I just don't think we'll get another Cape refund kind of deal like we had with all the IEEPA tariffs, but they could prove me wrong. That leads us to Section 301 tariffs. These are specifically forced labor 301 tariffs that became effective, ironically, not ironically, the same day as when the 122s went away. And obviously, that was by design, right? That's what I mean by the 122s were really a stopgap action. So the 301 tariffs, they require an investigation process where the 122s can kind of just happen by executive order. 301s have a process where they have to do an investigation. They have to go out for public comment, and then they come back and make a final determination. Well, obviously that was done here, right? We put the 122 tariffs in place for short term, then we that gives us the 5 month window to go put the 301 tariffs in place and make them effective the same day that the 122s went away. So 301 forced labor tariff came out in four different buckets. You have a flat 10% bucket, right? We won't talk about any of the countries listed there. You guys can just read those and see them, and I just put them there for reference in the presentation. But so that flat 10% bucket, that's just going to be 10% on top of whatever your duty rate is. That's going to apply. The only thing that it doesn't apply to is Canada and Mexico. If it's USMCA cargo, then this forced labor tariff does not apply. The USMCA will still exempt you from that. So those are kind of your baseline 10%. Then there's a 10% net of the MFN rate. And what MFN rate stands for is most favored nation rate. So what that really means is that you're going to pay your duty and then the tariff will net out at 10%. So if you're paying 3% duty rate on something, they're going to hit you with a 7% tariff. So you net out at 10% total. If you're not paying any duty, then they're going to hit you with the full 10% to net you out of 10. If you're paying more duty than 10%, so if you're paying something like, 15, 20% duty, then you're just going to pay that duty rate. So that's how that calculation is figured. Same with the one below that, right? Except it's 12.5%. So that's 12.5% net of most favored nation for those three countries. And then you have the flat 12.5% for all those other countries listed there. So that's kind of how this 301 tariff breaks out. Pretty fairly matched with the 122 tariffs, right? You're paying, some of those MFN rates, depending on what you're paying, you may be paying slightly less than you were before with the 122 tariffs. The 10% bucket, it's a straight swap, and maybe 2.5% more if you're in that last bucket. One thing I will say about these 301 tariffs is there are several exclusions to them. I put the link here. It's worth going to take a look at that link and make sure that if your product was excluded, that you're claiming that exclusion. It's another kind of pretty random list. Some of those countries have a handful of things that are excluded. Some of the countries have quite a bit that's excluded. It just kind of depends business with any of those countries, with which a lot of people probably are. It's worth the look to go kind of look through those, and it's just a long list of HTS numbers, right? So either your HTS number is on the list of exclusions and you can claim it, or it's not. There's not much you can. It's not like a program where you can kind of work yourself into an exclusion. It either is or isn't. But if you're on that exclusion list, it's worth the little bit of time to go take a look at that. One thing to note about this too is the countries not listed on the 301 forced labor list effectively received a tariff cut. So if you're not dealing with countries on this list, if you're dealing with somebody outside of this list, that 122 went away and hasn't been replaced with anything else for those other countries. So you're back to paying duty like normal with no real additional tariffs unless you're paying 232 tariffs. Whether that'll stand, I don't know. They might replace it with something else, but at least for the time being, you're kind of falling into a lucky category there where you're not paying, or you're paying very minimal duties unless you're or very minimal tariffs unless you've got a 232 tariff. Next tariff that came up is another Section 301 tariff. This one is a country-specific tariff targeting Brazil for unfair trade practices. This one's a little more traditional, like the forced labor tariff, right? That was kind of a stretch in some senses because it's about those other countries having, not that they're involved in forced labor, but they're not enforcing our same forced labor standards is kind of how they got that into place. But this one's more just about direct sort of Brazil having some unfair trade practices. So this one's a little more traditional than some of the other ones. So this is a 25% tariff on most imports from Brazil, but there is a very lengthy list of exclusions from that. So again, there's the link if you want to go look at that. It's worth the time if you're dealing with Brazil, or if you're thinking about dealing with Brazil, go in to look at that list. I mean, a lot of it is base chemical, kind of base component stuff, base metal stuff, fertilizer stuff, but there is lots of stuff on there. uh, some car parts, some airplane parts. There's all sorts of stuff on that list. So it's worth the look going to make sure that if you're going to deal with Brazil or not, to make sure you're not paying a tariff that you don't need to be paying because you're on an exclusion list. So another 301 tariff that is currently in investigation. So this one hasn't made it past the investigation stage yet. So it's not a actual tariff. We don't know when it's gonna come, but if it's gotten this far, it will eventually happen. So you can see all the countries involved here. This one is specifically targeting a structural excess manufacturing capacity. So I guess, these countries have more manufacturing than we'd like them to have, whatever that means. Um, but yeah, this one will kind of follow that same process. It'll eventually go out for a a public comment period, and then at that point they'll make some initial kind of indications of where this tariff might come in at. I think technically, don't quote me on this, but I think if memory serves me correct, 301s you can have as much as 50% tariff. That's kind of the upper limit of it. So this could potentially be as big as that. I don't know that it would be. Like I said, they haven't put out anything about it. We're still a little early for that. But the fact that the administration has taken it this far means that this is probably coming, right? The 301 tariffs, they're another, like the 232 tariffs, they're another tried and true um, sort of battle tested tariff category, right? Again, these were starting with the China 301 tariffs back in the first administration, back in 2018. These have been around for a while. They've gone through the courts. They've been legally contested and kind of they've maintained their ability to stay in effect and not be thrown out. So this is a category that when they take it this far, it's something to keep a pretty serious eye on because it's probably going to end up being something at some point here. So probably within the next quarter. They've been moving fairly quickly on these, right? The other 301 tariff went in within 5 months, and this investigation started just shortly after that one, so it's not far behind it. And if you see, right, a lot of these countries on here, there's two. So that kind of brings us to this idea of tariff stacking. 301 tariffs stack with other tariffs, and especially other 301 tariffs. So just because you're paying one doesn't mean you're not going to pay the other. If you're importing from China currently or Brazil, you're already living the dream here, right? Um, 301 tariff, the original China tariffs are stacking with the forced labor tariff. Same with Brazil, their tariffs are stacking with that forced labor tariff. So both those areas now, unless you're on some sort of an exclusion, are paying 37.5% just on the tariffs or just on the 301 tariffs. And 232 tariffs generally stack on top of that as well. So already you could be paying well over 50% in tariffs. Uh, with those new tariffs coming in, right? Again, those would most likely stack. They haven't come out with the rules on that yet, but those would most likely stack on top of these. So that's kind of for some of these countries, you're starting to creep up again to that 50, 60, 70% range. Where you're talking about really significant tariffs for some of those markets. Especially a place like China where a lot of people are doing a lot of sourcing, right? We had been as low as 10% recently, and now we're all of a sudden back to getting to potentially 50% or more. So it's a big impact. Uh, yeah, again, these tariffs have stood the legal challenge too. So once they're in place, they're not really going anywhere for a while. So this will have a long term. Any 301s you see, those will have a pretty long term impact on buying decisions and where you want to look at sourcing. Last tariff we'll talk about is Section 338 tariffs for Canada. This is a new proposed tariff of 50% targeting Canadian goods effective starting next week. This was announced, so they kind of gave it a bit of a runway. I think it was a 30-day runway here, but we're coming up pretty quickly on that effective date. Uh, like a lot of these other ones, it targets a whole bunch of random stuff, wine, beer, liquor, dairy products, furniture, clothing, hockey sticks. I mean, all it's a lot of random stuff. That was kind of done to get to a certain number of impact, a certain dollar number of impact on that economy. One thing that is might be of particular interest to this group is 843360.00, which is machines for cleaning, sorting, grading eggs, and other agricultural produce. That one's on the list, so that one could potentially be subject to this 50% tariff if it goes into place. Uh, so it's definitely something to keep an eye on in next week and seeing how what actually comes of this. If you want to see the full list of it, again, there's a link to the fact sheet that has the annex with the full list of all the HTS codes that are on that list that you can look at and see what could potentially impact you. But it's definitely something to keep an eye on. This tariff would not stack with 232 tariffs, but unlike some of the other ones, you're not exempt if it's USMCA. So if it's Canadian made goods and you're bringing it down, you could potentially still be paying this 50% tariff. So that's a big impact on some of that stuff. This would be so the 338 tariffs have actually been around for a long time. They were part of the original Taft-Hartley Tariff Act back before the Great Depression. But this would be the first time that any administration has ever used this tariff. So it's not something that is particularly tested. So you can imagine that we'll see pretty much immediate legal challenges to this. Whether it would actually hold up, I don't know. Your guess is as good as mine on that. But yeah, it's one that's kind of untested. And when we talk about USMCA here in a minute, it's what the actual motivation here is maybe potentially more of a negotiation tactic than anything else. But so jumping into USMCA, we're not going to go through this graphic. I just included it more as a reference because it's kind of the best thing that I've seen come across, sort of explain the timeline and sort of the different events and the different sort of hurdles within USMCA. And what kind of happens as we review those various deadlines. If the group kind of says yes, if the group says no, what sort of the impact is. um and one of those major hurdles in that USMCA agreement just passed here on July 1st. July 1st recently was when the agreement initially went into place. After a 6-year period, the three countries were supposed to get together and agree if they wanted to extend the original agreement out past its first 2036 deadline. I think it was another maybe 13 or 14-year period. It's probably in this graphic here, but 13, 14-year period that it would just automatically extend out for. We decided not to do that, particularly the US decided not to do that. So as of July 1st, we now kind of enter a different phase of USMCA. Not that the agreement goes away, the agreement remains in effect. It's still got quite a few years, another 10 years before it would actually potentially go away. But what happens by not agreeing to renew that, we enter a cycle of a yearly review process for at least the next 3 years. And with each of those yearly review processes, it's an ongoing negotiation. It's a potential for changes to be made to the agreement. It just creates a lot of uncertainty on to what might happen in the near future, which, if you're manufacturing or buying from Canada or Mexico, that brings a certain amount of risk to everybody, to what their costs might be, a year from now, or whether they invest in a manufacturing facility there or not. So, kind of the current stance of where we're at, the U.S. is carrying out bilateral negotiations with Canada and Mexico, or should be. There's been three official rounds of negotiation with Mexico, no formal rounds with Canada. Although there's probably a lot of unofficial and backroom negotiations going on here. That's at least the official stance of where we are. That's kind of where that 338 Canadian tariff comes in that we just discussed. Is that a negotiation tactic to get Canada to actually come to the table, and really kind of discuss either a bilateral or a different version of the USMCA agreement? Some people think so. It would definitely be in character with the administration, right? That's been kind of a hallmark of their negotiation style is, big tariff, big announcement, big something, short deadline, kind of get people talking. Maybe it doesn't go into effect, maybe it gets extended, maybe it only goes into effect for a couple of days and then gets recalled back. Those have all been kind of things that he's done, or that the Trump administration has done very recently, and kind of on par with their negotiation tactics. So, is that a negotiation tactic? Is that 338 Canadian tariff a negotiation tactic to push that potentially? Is it something that just is out of nowhere, and we're just kind of pushing forward, that's as likely as the other scenario too? So I really honestly don't know. Your guess is as good as mine there. But what I can say is we're essentially watching three negotiations happen in unison right now, right? It's a bilateral negotiation between us and Mexico, us and Canada, and really a lack of negotiation of the USMCA at this point, right? We just kind of kicked the can down the road on USMCA to a review next year. So kind of depending on what happens with those bilateral agreements, that'll probably impact what ends up getting reviewed next year in that mandatory USMCA review component, and for the next 3 years, really, for that matter. So we'll have to just watch and see what happens. I think the only degree of certainty here is that you're just gonna have more uncertainty with these trade agreements until something finally gets settled with that. So last section we'll talk about here is increased customs enforcement. And increased customs enforcement has been something for a while. It's been kind of bubbling up for a while, so it's not necessarily new, uh, but it is something that in the last quarter has definitely ratcheted up, and is definitely picking up steam. And there's a couple of reasons for that. One is tariffs themselves, right? A lot of the avoidance strategies that some of the suppliers took to get around tariffs or transship stuff like that. That's something that customs and the administration is looking to address. Um, so that's causing increased enforcement. And then beyond that, you've got the kind of the rise of automated enforcement techniques, specifically a lot of AI and other sort of computer digital based enforcement that they weren't able to do until recently, right? Everything had to have somebody's eyes on it at customs. It had to be a visual process to sort of review that stuff. Um, Now moving into sort of automated enforcement and AI enforcement and various AI tools, customs can start to look at a lot more information than they could in the past and still be efficient about it. So you see customs sort of moving into this adoption phase of technology and really kind of piecing together uh, supply chains of and seeing what companies are doing more efficiently to better target individual enforcement. Um, some of these enforcement signals are more subtle, right? There's uh, more requirements for other government agencies. That's, Department of Ag, DOT, USDA, all those CPSC. If any of you guys are dealing with CPSC, you know that there's brand new CPSC filing that's having to be done now, rather than presenting certificates of conformity on request. Now you're having to file a paper trail of those certificates of conformity on every entry that you do. Um, that's the kind of enforcement that they're moving towards. Again, like they're able to see that because of the technology now that's behind it. They're able to have eyes on that without actually having to have eyes on that and do better enforcement that way. Additionally, ADCVD, which is anti-dumping countervailing duties, and UFLPA. We'll talk about both those here in a second. Um, some of the other enforcement signals are much more direct, right? There was a executive order in July about strengthening customs enforcement. We'll talk about that in more detail here too in a second. But what really is the takeaway here is that any importer, regardless of what you're bringing in, needs to be aware that there's this increased enforcement environment. And really, while that's building, you should really be taking the steps now to formalize your customs compliance SOP, right? Look at potential possible changes that you need to make to your import program to mitigate any liability. Uh, Doing that stuff now while this enforcement is building and developing puts you ahead of the curve. So as you're starting to deal with this enforcement, you're more ready to kind of prove that you have some level of due diligence. You've done some level of due diligence, right? You're one of the good actors. You're not necessarily one of the people who's just kind of out there flying by the seat of their pants. So let's talk about anti-dumping countervailing duties. Anti-dumping countervailing duties are, if any of you guys have ever dealt with them, right? They are basically cases that specifically target a commodity and countries, specific countries. So, it'll be wooden bedroom furniture from China or something along those lines. Um, these are different than tariffs because there's a long investigation cycle. Usually the investigation cycle starts by, an individual company or a lot of times a trade association will bring a anti-dumping case against a certain country for a certain commodity. Um, and that will start that investigation process. And then there's a process of kind of proving that there was initial damage. Then you got to go and show how that it was actually, they're actually selling below cost. They're selling below the actual cost to produce the item. And then after you do that, there's a final determination process, but of what the anti-dumping rate actually will be. A lot of these cases, though, they take a year or more, even a couple of years before they get finalized. So this is a long process, but um, when there is a final determination, a lot of times those are big duty numbers. They're 85, they're 125, they're up to 300%. And they're on specific industries, from and maybe across multiple countries, and against even down to specific suppliers, especially if there's individual suppliers that they feel are government backed or government subsidized in some sort of way. So it's something, and the number of new cases, the reason I bring this has always been around, anti-dumping's been around for a long time, but The reason I bring it up here in sort of this new enforcement environment is that the number of cases of new cases that they're looking into, that Customs is looking into, it's just exploded. It used to be that most customs brokers knew every commodity that had an anti-dumping duty and every commodity that was under investigation, that we had them all memorized, right? Maybe there was one or two a year that were under investigation, and the list of commodities that were actually subject to anti-dumping, was 10 or 12 or something. It wasn't very many. We all kind of knew the categories. This has now developed into something where it's beyond the ability for anyone to keep it all in their memory, which makes it a lot more dangerous in this environment because with customs trying to use this as a enforcement technique, and you're not able to kind of have a wide picture of everything. You really have to go out of your way to make sure, and this goes back to developing an SOP for compliance, right? You have to make sure to go out of your way and look for those, not only what's being charged anti-dumping duty now, but what could potentially be charged anti-dumping duty in the future. And I included the International Trade Administration search page there, so you can go and start looking. The dangerous part about anti-dumping and countervailing is that it can be retroactive. So a case that is going on right now could potentially go retroactive for 2 years at 100% duty rate. And you think you're fine, everything's great, but you don't know about this case that's sort of pending out there, and all of a sudden you get hit with a tariff bill or a anti-dumping bill for hundreds of thousands of dollars because they made it retroactive for 18 months. So it's something that, again, especially people doing purchasing, part of your compliance department, this is something that you should be periodically reviewing, because there's always new stuff added. There's always you want to make sure that anything you are buying now is not on a potential investigation list. I think for the majority of this group, probably not. I did do a short review of kind of what's out there right now, and I don't think, but I don't know all your guys' industries or what everybody's involved in. So, um, is there anything really directed at ag machinery? No, not necessarily, but if you got a different aspect of your business, it's make sure to be checking this to make sure you don't get caught with something here. Next thing we'll talk about is UFLPA, which is the Uyghur Forced Labor Prevention Act. This has been around for a few years. This isn't necessarily new. This was initially focused on kind of a few sort of specific commodities that were directly sourced and mined, processed, or produced in China's Uyghur region. And the Uyghurs are a minority within China, and that region where they're at. That's kind of where they send the prison labor, and there's a lot of bad stuff going on there, and that's kind of a lot of forced labor used in production. Um, what is important about this, even though this has been around for a while, is that the enforcement has gradually been expanding, the list of targeted commodities and the list of um, entities that are restricted, and how that plays out with scrutinizing supply chains for downstream manufacturers has gradually increased. When this started, it was basically like just cotton and cotton products, some of the silica-based products, some of like the tomato products, right? It was a pretty narrow list, but you can see it's ratcheted up quite a bit here with some of the stuff that's pretty ubiquitous, right? Aluminum, copper, that kind of stuff. That's lithium if you're dealing with anything with batteries, right? That stuff's all pretty ubiquitous in production now, and they've really kind of gone after increasing what they're looking at and the scope of it. And I put the list of restricted entities there, and so that you can review it or at least know that it exists more than anything else. I don't know necessarily review it, but at least know that it exists. And you'll see why that's important here in a second. So the reason that this is on the list is not only have they been gradually ratcheting up, but in June, CBP issued a this advisement on the forced labor enforcement and kind of gave a lot more guidance to importers about how this is going to be, um, how they're going to handle this going forward with exclusions and seizures and reviews and protests and all that kind of stuff. They're going after a lot more than they used to. Um, and with Ufflepaw, it is, or anything forced labor, it's guilty until proven innocent, not innocent until proven guilty. If you get a withhold release order or a seizure, you have to prove that it's on you as the importer to prove that your product was not produced with forced labor, not the other way around, right? It's not incumbent on customs to say this is how we know that you're using forced labor. It's on them to go. It's on you to go the other direction with it. Uh, and really, the only way you can do that, or the best practice to do that, is supply chain mapping and documentation. That's going to become really important for people because it's the only way to kind of get it out in front of that ahead of time. If you do get one of these detention orders and you need to contest it, um, how far you take that and how far you go with that really kind of depends on your industry and how much risk there is. And are you sourcing aluminum out of China, or is one of your manufacturers sourcing aluminum out of China? Then yeah, that might be a risk factor, and that's where knowing that list of companies that are excluded or are being this list of restricted entities, that's where that's important, because if you see one of those names pop up, you definitely want to, or anything close to it, right? You want to make sure that you're doing your due diligence there to either find alternate suppliers or to get away from that altogether. Um, if your supply chain is, if you're buying from Italy and you're sourcing steel and you talk to your Italian manufacturer and they say we're buying our steel out of Poland, do you really need to go to the ends of the earth of it? No, probably not. But just kind of depends on what your supply chain looks like. But it is definitely going to be best practice to get out ahead of this, especially the closer your supply chain is to China or some of those kind of critical commodities that they list there. Um, just kind of a personal story there. I have personally seen someone get a withhold release order. They were importing vinyl plank flooring. So PVC is on that list, but you not necessarily vinyl plank flooring. So you wouldn't think that that'd be a high risk situation. Um, but they got a withhold release order. They had, I think, something like 40 containers on the water, and every single one of them got a withhold release order. So that all stacked up here while they were trying to prove that they weren't using any sort of forced labor at all. And while it sits here, the realities of shipping are still there, right? Detention, demurrage, all that kind of stuff. So it sat there and piled up just a huge bill. Um, in the end, he wasn't able to provide enough evidence. Um, Not that he wasn't used, but he wasn't able to provide enough evidence that he wasn't essentially not guilty to kind of get himself out of that predicament. So they ended up having to re-export all that cargo, and it cost a whole bunch of money. So that's the kind of thing that you like I said, you really want to try and get out in front of now while you can see it coming, and while you have time to deal with it, because if and when it ever happens to you, all of a sudden it's just going to be a big problem, and it's going to continue to cost a bunch of money and other issues that you don't want to deal with beyond just the black eye with customs, that now they're looking at you as a potential forced labor violator. So last thing I'll touch on here is this, and this is kind of the one that was blatant that I told you about right in the beginning, is this June executive order that was issued by the president, regarding strengthening customs enforcement, right? This order is a directive to the Department of Homeland Security to establish new rules within 45, 90, and 180 days for dealing with increasing customs enforcement. So there's not a lot of substance in this executive order. You can go read it, um, but it's more directive that from the top down that we're moving into an environment that there's going to be a lot more eyes on things and a lot more regulations on things. This it specifically calls out new requirements for foreign importers of record. So if you're buying anything DDP right now, that likely is going to change. Because new bonding requirements for foreign importers. They are, they're trying to get rid of any the guys that just have kind of LLCs that are here that don't really do anything, that they're using as just import companies. It's going to bring about some major changes, and that again, that has to do a lot with the tariff evasion that happened, where people were multiple copies of invoices that were undervaluing product, a lot of stuff like that that they're not able to enforce under the current rules, because the best they can do is issue a CF-28, which is a request for information that goes over to a Chinese company or somebody that's just really without outside the grasp of the U.S. jurisdiction, and they can kind of disappear with little or no real ramifications, right? They're not going to pay a penalty. They just kind of disappear and go. All of this is kind of meant to deal with some of that, but in that process, there's also going to be a requirement that importers maintain this good standing status. What that is hasn't been defined yet, right? But there's definitely more to come with this. Um, and it's something that um, there's definitely more to come with this, and you can see here it's just more kind of bullet points from that. All right, the executive order wants to expedite and enhance the seizure and disposal of non-compliant import products. Um, Minimum penalties are going to go way up. Increase vetting procedures for even your customs brokers and your freight forwarders. There's a whole bunch of potential impacts here and what actually comes out. I think that first 45-day deadline, which we're pretty quickly approaching, um, is there should be some initial rules, and then there's some additional recommendations, and by that 180-day mark, there's going to be some definite changes here. So really, by the end of the year, you're going to see a lot of changes pretty quickly here as to what requirements are for importers and what the enforcement situation will be. This is actually something that we'll be talking about, or I'll be talking about at the October conference. Once we have a little more information, we'll have a breakout session about this. So hopefully we kind of know more, and I can kind of explain a little more about what is specifically going to happen for guys who are buying DDP. What does it really mean for the penalties changing? What are the forwarders? Are you working with CT? Do you have to be working with CT-PAT brokers? Do you have to be working with CT-PAT forwarders? There's a lot of unknown there that hopefully gets cleared up by the end of October when we're in New Orleans. So that's the end of what I had. Celeste, I don't know if there were any questions along the way there.
There's no questions that were listed. Does anybody have any questions before we wrap up? All right. Well, then, Steve, thank you so much for joining us
Absolutely.
today and
Yeah.
sharing your insight. There's certainly a lot for businesses to navigate right now, and we appreciate you helping us break down what our members should be paying attention to and thinking about as we move forward. And then thank you everyone who's attended today. We know your time is valuable and we appreciate you choosing to spend part of your day with us. At EMDA, we are, one of our main goals is to continue providing resources and education like this that help our members navigate challenges and opportunities that affect the industry. So if you have any topics or anything you want us to cover in the future, please do not hesitate to reach out. Your feedback helps, provide better programming that's valuable and relevant to everyone. Again, thank you, Steve. Thank you for mentioning the fall convention. We hope everybody's signing up for that. We can't wait to see your presentation there as well. And we hope to see you at the fall convention. But again, thank you everyone for attending. If you have any questions, please don't hesitate to reach out. Steve's going to reach out with his PowerPoint. And if you have any further questions you want to ask him. But otherwise, I hope everybody has a wonderful rest of your day.